So section 2, on confidentiality and legal compliance. A lot of questions come from this. Okay, so here you have altogether 8 standards, standard 2.1 to 2.8. Okay, so you have a lot of standards here under legal compliance. So here we'll go through each one of them very quickly, and then after that we kind of do a little revision to help everyone to kind of be familiar with this part on section number 2. 2.1, standard 2.1, it says that maintain the strictest level of confidentiality with all parties involved, regardless of the role I'm fulfilling. Okay, so what on earth is this part here? Okay, so there is different kinds of confidentiality that we have to uphold. One is upholding standards. So whether your coaching notes are securely stored, or how long should they be stored for? When should you dispose of it? Okay, so this is one. Another violation could be a coach shares a success story about a client during a workshop, though no names were mentioned, but the details were specific enough that the client could be identified. So this is something very important. Usually when I want to share a success story, I make it fictional. I let everybody know, okay, this is inspired by a real event. Okay, and I have to change the actual situation, the actual industry to provide to cover confidentiality. So this is very, very important. Recently, I saw on LinkedIn and I saw on social media, some coaches are going online and say, oh, recently I was coaching this person, and they start bragging about the client. And I know some clients are feeling very uncomfortable because a lot of details, and then they tag the company name as well, and they post a picture of the person. So I understand it's for marketing purposes, but we need to get very clear verbal confirmation from the client. Now, if it's coming from the client's end, say for example, today, if Chris is my client, and Chris goes online on LinkedIn, and she says, oh, I had a great experience with Jedi, coming from the client's end, that's perfectly fine, because the client's the one saying. But it's coming from my end. Let's say tomorrow I post a picture of Chris and I say, oh, during the workshop yesterday, Chris, had a breakthrough, then it's too much. Right? It's crossing. So this is a violation here. Okay. Now, there'll also be cases where there's subtle breach. So in supervision cases or coaching supervision cases, the coach brings up a case without using the client's name, but includes very specific job title and incident. Though well-meaning, the supervisor knows the client personally. So what is supervision? Coaching supervision is when you're having a large organization coaching, and sometimes you meet with certain cases or case studies or case issues where it's not so easy to kind of address. That's when you bring it up. And sometimes the supervisor might be also an internal leader, or might be someone who may know the individual as well. So during supervision session as well, the supervisor, though is a neutral party, would always prefer for you to anonymize the sharing so that it provides any confidentiality as well. So the keyword here, anything that supports confidentiality. Okay. Now, for 2.1, very, very important as well is this other part here. So I'll highlight this part here. Here, confidentiality is foundational to the coaching relationship. So ICF takes confidentiality very seriously, very, very seriously, right? So if you see anything on confidentiality, know it must be at the strictest level. Okay, so you take a look at the questions and answers. Anything on confidentiality upholds the highest level, option A, B, C, D, the highest level, that will be the answer. Okay, the strictest level. Now, also any known confidentiality related considerations that might come up in the coaching agreement must be addressed, clarified, and agreed upon all parties. So this will go back to the part 1 of the Code of Ethics, talking about the ICF ecosystems. Okay, so which means all the family units or family organizations or ICF must abide by this. Okay, so here it's where it says this: ICF professionals should rely on ethical principle of informed consent to give sufficient information regarding the purpose of the Code of Ethics, and is advised to consider remitting a copy of Code of Ethics to the other parties contracted. So we talked about this earlier, where informed consent means we let the person understand fully what this Code of Ethics is all about. So if you're engaging with an organization, always useful to have a session to go through the entire Code of Ethics with them. Highlight several key important elements so that it prevents any miscommunication at the end. Yeah. Okay. So the ICF professional best practices is have an understanding, written or otherwise, that all client-sponsored information communication must be held confidential prior to being hired by the client or sponsor during the coaching engagement and or after the conclusion of the engagement. And also set up and abide by policies on record keeping. So this is very, very important. You have a question on this, right? About how you keep records in your computer. which protects data from hackers, thieves, wandering eyes and ears, training of staff or support personnel on the importance of maintaining confidentiality relating to all parties. So some people ask me, say, Jedi, how come we don't see you post a lot of videos, testimonials on LinkedIn and stuff? I said, because I don't have permission for all clients to post. So those things I post on YouTube are verbal confirmation from clients that give me verbal confirmation. So sometimes clients may also ask you, hey, do you have any testimonials? Testimonials or any recommendation must also be gotten or be approved. Permission must be given by the client as well. Okay. Now, also, safeguarding confidentiality and complying with all relevant data protection policies in Singapore would be PDPA. In European nations will be GDPR. ICF will be abiding by the GDPR regulations as well. Okay. Now, this also applies to the use of digital media and application platform software, social media, which is all the other devices. Okay. Now, also, you see this. So ICF abides by the GDPR regulations. Okay. So, and the rest of the countries, you have to look at your own country regulations or data privacy. Now, recognize that when an ICF professional acts in another role other than a coach within the same organization, it is incumbent on the ICF professional to inform the others if confidentiality rules apply differently. Okay, so this is something important as well. There will be a scenario that's based on this. Okay, so when you have another role other than a coach, okay, so note other roles can include but not limited to consultant, facilitator, trainer, business mentor, or others. So if you have two different roles and they are governed by different ethical guidelines, you have to highlight them accordingly. Also, ICF professionals should be aware of the information on company-owned resources. Okay, may be accessible by others. So hence, full confidentiality is not guaranteed. It is therefore recommended that ICF professionals consider how to maintain confidentiality while being compliant with data protection requirements. So sometimes within the company, you may be using the company's Teams, Google, or other platforms that may be shared or may be leaked. It's not unintentional, but you have to anticipate some of this possible leaks. I give you an example. Recently, Microsoft faced a huge challenge on SharePoint. If for those who are familiar with SharePoint is like a one of the tools on Microsoft that a lot of organizations use, and there was a leak. So people outside the organization can tap into the SharePoint access folders and control the computer directly, and a lot of data got leaked out. So we want to also be very careful of how we note all these things down. One of the ways to kind of ensure compliance or data privacy, I always encourage coaches to use shorthand. Right. So if you are familiar with shorthand, means you write in a way that nobody can understand, only you can understand. So that will prevent any form of implications in the long term. Okay. Good. So this is 2.1. Very, very straightforward. Okay. Now 2.2. Have a clear agreement about what information is exchanged and how. So this part here, when we look at 2.2, this is where all parties involved during engagement, right? So how is it exchanged? So there's two parts, what and how. So let me highlight this part here, what information and how. Okay, so what it means is this. For example, if you're doing a 360 feedback, what is it that you're offering? What is it that you're sharing? What is it that should be exchanged? Can I share the document with the manager? Should the manager share me the document? Or, for example, the coach verbally promises confidentiality but fails to clarify what can be shared later. And then later, the sponsor requests session details and the coach feel pressure to provide them. So sometimes this is the part where we say it's better to kind of write it in writing, especially for confidentiality, to prevent any misunderstanding at the later stage. Okay. Now, also sometimes there can be ambiguity. So in team coaching, the client believes that they say in the group a reflection is private, while the coach shares this reflection with the HR to help the system or help the organization. Now, sometimes for team coaching as well, although we say it's private, whatever is shared is private, sometimes team members, when they hear it, they may go and report this to their HR people. So this is where you have to think and decide with the team as well, what is the best way of protecting everybody's individual rights and confidentiality. Yeah. Okay. So what this means is here. Be very clear about how everyone's involved in the coaching process. When, how, what, and the ways in which coaching information and confidential information is shared. Okay, so things like their names, every single thing, right? So, and also discuss how to protect the client from unauthorized disclosure or indirect communication amongst parties. For example, an ICF professional is responsible for clarifying the framework and process regarding sharing reports. So sometimes as a coach, you may have a coaching report you need to share. So do we share with everybody? How do we lock the document so that it's only accessible to that individual? How do we create a document that expires at a certain date, right? So this is something to think about. It's, using technology to support you. You can also do what we call crypto. That means use some crypto software to help you to encrypt the particular document to ensure confidentiality as well. Okay. Now, so the rules of confidentiality must be clear to all participants before coaching begins. And this is where it referenced 2.1 or standard 2.1 about confidentiality. So balancing that of ethical standards identified in the code of and the ICF professional ethical judgment as well. So your ethical judgment against the code. So sometimes you got to make a decision and a call. What is the best way to maintain confidentiality, especially when it's very, very ambiguous? Okay, so although ICF encourages having a written contract, even a verbal agreement, the ICF professional should take into consideration and make sure the terms of information shared are clearly understood by all parties involved. And so sometimes you want to have a read back from the person whether they understood it clearly. Okay, so this is again to prevent any miscommunication. So sometimes when working with an SME or smaller companies, they may not want everything in writing. They might say, hey, I'm the boss, like whatever, you can just coach my people, right? Don't need to have all these things. So sometimes the big boss may do something like this. So this is where we got to ensure that everyone understands clearly. Yeah. Okay, so that is 2.2. Any questions with 2.2 from anyone?
Not 2.2, but I think it's 2.1. I just have a question. Curious question about notes. Just now you mentioned, right? When a coach takes notes, number one, it is actually something that's for you. The client can't actually ask you for your notes, right?
So this is where you have to let the client know. So usually I would say, right, okay, so let's say I have a coaching relationship with you, and I say, hey, Chris, okay, before we begin, I want to highlight to you that during our coaching engagement, you will see me writing notes. Okay, so if I'm looking downwards, I'm capturing some notes, and I'll encourage you also write notes yourself. So the notes I'll be writing is for me to keep track of where we are in our progress. And I want you to write notes because I want you to capture your learnings and insights that you gain. So at certain juncture of the conversation, I may encourage you to pause, capture some of the insights you're gaining so that we can look back again at these notes, after a few sessions and see how far we've come. Would that be okay for you? Something like this.
Okay. But even after that, let's say permission to write notes. At no point can the client ask you for my notes, right?
Yes, of course. Of course. Now, of course, sometimes some clients say, oh, how can you like this? I allow you to take notes and why don't share me? Can you share me? Right. So this one, that's why they say this, they understand that some culture, because we only use verbal agreement. So maybe at the start, the client, agrees with you verbally.
Okay.
But they say, please, Chris, my handwriting is terrible. Can you please share me? Yeah, share me, please lah.
Yeah, because I'm concerned about the keeping on. I'm just asking this not because I refuse to share my notes. I'm just wondering whether there's any legal basis or legal guidance. How long do you need to keep it? One fine day the client asks you for it and you don't have it, then he not happy. Does it work that way?
Yeah, possible.
Oh, really?
Yeah. So sometimes the client may ask you to keep. So let's say you keep the record, right? But you need to let the client know I'm going to keep this one for up to X number of months after our coaching engagement, and after that I will delete it. So would that be okay for you? So you let the client know that I'll be capturing some notes, but how long I will store it for, and then after that what will happen to it.
Okay. I have a related question. Sorry. Just now we talked about the recording for the purpose of passing, right? Attending ACC. We discussed this before that a lot of the sort of contract agreement, breaking the ice, and all that should not be part of the 45 minutes. I should assume that all those things are already done. And this thing about writing notes and all that should be part of that. Yeah. Do you have something that has a list of things that is supposed to be just not inside that 45, or it's up to us to see which is good and which is not good?
You mean in the session? In the
Yeah,
coaching?
in the session, yeah.
In the session is whatever that we cover in class, which is
So it's just concentrate on the competencies, basically.
correct, correct.
Some of this admin and note taking, all that should be
Yeah.
assumed done already.
Correct. Yes.
Okay.
Anything administrative, financial, logistics should have been done before the actual session. Yeah. So sometimes, okay, what could happen as well if you have a 45-minute coaching conversation? So usually I'll say my coaching, okay, let's say you engage me as a coach. I'll say, okay, Chris, our coaching session is about 45 minutes. And we typically will spend about 40 minutes really doing the coaching. The last 5 minutes we'll spend on any administrative maybe I'll trying to book the next session.
Yeah.
So officially about 40 minutes with 5 minutes of logistics. Would that be okay for you? So I'll let you know that this is how we frame the coaching conversation.
But for the purpose of recording, I think it is you're not expecting us to sort of
No.
sing.
Yeah, you don't say all this logistics.
Yeah, we don't
Yeah.
have to, right? Okay,
Yeah.
okay.
Yeah.
Can
So-
thanks.
Yeah.
Yeah.
So if we recall, right, the competency tree, okay, so CC3 has two parts. We have what we call formative agreement. Okay, this is the part that we sometimes we call discovery session, onboarding, kickoff session, or whatever session. Okay, different terms, but this the same thing, which is I talk to you about how do we contact, how do we liaise, do we use Zoom, do we use Google Meets, what do we do? Formative agreement, right? And then sessional agreement means this is what we're going to do every single session. And what you're evaluated on at ACC or PCC level is the sessional agreement. Yeah, which is the start of the competency all the way through. Yeah. Okay, so sessional agreement you'll be tested on CC3, 3 to 8. Okay, so of course 1 and 2 is given. That means you're supposed to do demonstrate ethics anyway. Yeah. Okay, good. Okay, so now let's go to 3. Okay, so this part here, standard 3. Have a clear agreement with clients, sponsors, and other involved parties about what is confidential information may need to be disclosed to appropriate authorities, like example, illegal activity required by law, valid court order, subpoena, or imminent risk or danger to self and others. So here, very, very, very important. You need to understand this part here. Imminent risk of danger to self or others. Where can you find this? This can be found in the white paper in the Google Classroom of when to refer clients to mental health needs, or refer to any of the resources like the mental health resource that I showed you in the Singapore website. That's also same thing, because sometimes you read a scenario where the client talks about having suicidal ideation, talks about harming themselves, and what should you do at a point of time. Okay, even though you have confidentiality, should you review it? Should not review it? Okay, so confidential doesn't mean confidential to a fault, to the fault. There is a certain boundary where I need to disclose. Okay, so here, let's go a little deeper here. Yeah, okay, this part here very, very critical. Okay, now, although it's foundational, although it's to the strictest, highest level, but we have to look at it from the law as well. So, ICF professionals should make sure that they know the details of local laws. Okay, very, very important. Okay, local laws, which is whichever country we belong to, whether Malaysia, Singapore, Taiwan, or Japan. When a person has made a credible threat to them to harm themselves, their organization, or the others. So this is something also very, very important. Yeah, and also when the ICF professional is required by a court order or subpoena, the ICF professional must provide the information requested by the court or subpoena. Note: ICF professionals have no client privilege in a court of law. So sometimes you hear these things that the client will say, "Oh, I plead the fifth." Okay, this is in the US context. I plead the fifth. What does it mean? Okay, so I do not incriminate myself. I plead the Fifth Amendment. But in the court, in the eyes of the court, for coaching, there is no client privilege in a court of law. So I cannot say I plead the fifth. I cannot review anything. In a court of law in the US, if I'm a doctor client, I have client privilege, which means I don't have to review anything. Right? But in a court of law across the world, there is no client privilege, right? So, which means that if the court demands for me to provide information, I have to do it. I have to comply. And this is something that we have to talk to our lawyers if and when something like that happens. Okay, you have to talk to your lawyers accordingly. Okay, now, so reasons defined by contract with client or with client sponsor. When the coaching agreement allows informed consent on the part of the client, the coach applies. Or when the sponsor agreement allows and the client agrees. Or when the ICF professional is required to substantiate basic information about the coaching process for ICF professional credentialing or re-credentialing without sharing any client or personal information. However, ICF professional is responsible for obtaining client's permission in the event of confidentiality breach. So that's why when you guys submit your coaching recording to me, right, and I'm one of the approved assessors of the ICF, so that's why I'll also ask everyone to make sure that we have the client's permission, right, to take note of, right, whether in writing or in verbalized. Okay, so when the ICF professional needs to talk about a case with their mentor or coach supervisor without sharing any client or personal information. Okay, so this is something important as well. Okay, so here, very, very important, it is the ICF professional's responsibility to ensure that they know the details of the local law and should establish legal forum that governs the contract. The coaching industry is currently unregulated and has no special legal protection, and a legal specialist can be helpful. Why is it unregulated? Because it's still a growing industry. Mentoring, training, facilitation are also unregulated. Therapy is also unregulated. Yeah. So today anybody can call themselves a therapist, right? Because it's unregulated as well. In the event of a dispute, individually concluded contracts are judged according to civil law. So this is where you have to understand your own local law, disputes within a commercial contract, allegations of client poaching or others. So this is something very, very important. You can understand the civil law. Whether available in their country, it is recommended that ICF professionals get a professional service insurance policy for coaches. So in the US, we have this thing called liability insurance that I encourage all coaches to get. In your own country, just be aware of what are the insurance you need to get for yourself to protect yourself against any form of such allegations. Yep. Okay. Now, it is the responsibility of the ICF professional to ensure that that the coaching client knows when the ICF professional is required to breach confidentiality. And ICF professionals are to discuss confidentiality prior to the beginning of the coaching engagement. So this is where we refer to Chris' question earlier, right? Not during the session, but way, way, way before. Okay. And also in writing or in verbal, right? If information was not initially covered by the agreement, it happened at a later stage, the ICF professional should obtain the specific consent of the client and document the amendment before breaking confidentiality. Okay, so this is something important as well. So some of the best practices: inform the client that discussions around confidentiality may come up at any time. So usually at the start, way, way, way before we even have the session, I'll let them know that to avoid any topic that may be grounds of confidentiality interest. For example, the client gives me some insider knowledge, insider trading, or some secret information. Okay, so I will always advise client, nothing confidential, nothing to do with the company. Keep it as anonymous as possible. Just give me the context. Let's go deeper. Okay, seek supervision if one of the parties to the agreement is in a vulnerable situation. Okay, or seek ethical advice through resources made available by ICF. Okay, now sometimes coaching for some populations may be more nuanced, requiring further considerations. So sometimes if you're coaching special needs, if you're coaching certain groups of individuals within the in society as well, you have to abide by that societal norms or the association norms as well. Okay, so for example, internal coaches may find themselves in a situation of conflict between their duty towards organization and interests of their coaching client. So this is where you got to talk to the organization leaders and to ensure alignment. Now, also, sometimes external coaches may find themselves in a situation of conflict where they hold more than one role in an engagement. For example, you're a trainer plus coach, consultant, coach, therapist, right? So I've seen some coaches that they say that they are all in one coach. So they basically do everything. We call it the Pao Kao coach, you know. So very important to make sure that there's no conflict so that everyone understands their role. Okay. Now, on the coaching of minors, this is very, very important. Minors, minors refer to individuals who have certain legal, ethical age by different countries' standards. Okay, so ICF professionals will consider the legal and ethical considerations around the protection of minors' privacy, while also recognizing the roles and responsibilities of parents or legal guardians. This is especially when you're coaching anyone who is young or of a different sex. Okay, so for guys coaching girls, or girls coaching guys, or ladies coaching men coaching women, very important to consider all these different factors as well. Yeah. So protection of minors' privacy. In this context, the way confidentiality is handled depends on the jurisdiction and specific coaching relationships. So some general ethical principles do apply when protecting the minor coaching client's interests while also respecting the requirement to keep it legally responsible person involved. So if those of you who are doing parenting coaching or coaching for children or coaching for youths, okay, very, very important to speak to a local ministry or local governmental body or society or law to understand the legal requirements as well. So it protects yourself in case of any issues. So, for example, for men generally, if you're coaching someone of opposite sex, I always encourage you to do it in the open space for whatever reasons. Even if the person feels very confident, right? Keep it in the open space to provide any misunderstanding. Okay. Now, this includes the following measure: communicate clearly to the minor and the parents that there are exceptions to confidentiality, and the legal obligation and requirement in many countries is to report reasonable or actual harm, abuse, or neglect to proper authorities. For example, I've came across cases before in the past when I was coaching youth at risk. There were cases where the youth come and tell me that there was harm and abuse at home. The parents were attacking each other, and then because I was informed by the young person about this, I have to report it accordingly to the correct agencies. Yeah. So every countries, you would have your own line of authority to kind of report to. Okay. The agreement should be updated with aforementioned discussions reviewed with the minor and parent on the clarity of content, expectations, and what type of information will be exchanged and how information will be exchanged. Specifically with whom or who the information is exchanged with. So for minors, very, very important to just be mindful of how do you handle them. Okay. Now, also increasingly, a lot more coaches are coaching people with disabilities or people with different spectrums. So this is something also to take note of. According to the different organizational norms or societal norms and legal requirements, you have to abide by that as well. Okay, good. Any questions here for standard 2.3?
I have a question about the agreement for children, right?
Yes.
I mean, if let's say children are the clients and the parents are sponsors, so in this case, how do we do contracting? Because the children may not be able to understand the legal terms.
So you have the contract with the parents, which are the sponsors. And you also highlight to the parents that I would also let your child know about how we're going to have the conversation. If at any point of time the child don't feel comfortable, I reserve the right to break the coaching agreement, or we have to cancel or reach to a closure for the coaching agreement. Yeah.
And we also explain the same to the children as well.
Depending on the age of reason of the child. So, for example, if you're coaching youths who are 18, 17, 18, they can understand. If you're coaching someone younger, let's say 13, 12, 11, 10, they may not understand. So, it's always important to get the parents and to sit down with the parents and the child to let them know that they'll be going through this coaching session with a professional coach. Yeah.
Sorry, I have another question before this one. Related to the agreement as well. So just now, I think it is quite clear that the agreement is very important in this coaching relationship, right?
Yep.
So while the client will have gone through the agreement, when we send all this, do we also kind of like set up a session to explain to them that they are fully aware of what is written in the agreement to make sure that we are on the same page?
Yes, you should have a session about that to clarify and then check in with them, to make sure that, because sometimes some people just they scroll through and then just click agree, but they don't read the terms and conditions. So it's also important on your role as the coach to highlight certain key information to them. So I give an example, right? When coaches come to me and say, "Oh, Jedi, can I attend level 1, level 2, level 3 training with you to become ACC, BC, MCC?" I always let them know clearly. I said, "Okay, the course fee doesn't cover ICF application. Okay, there'll be additional fees. You may fail, and then so I don't guarantee anybody that they will pass." Okay, so this is an example, right? So in the same way for coaching as well, some coaches say, "Oh, you definitely get a breakthrough. You will definitely get some transformation." And this kind of like definite terms are very, very important not to, you have to be very careful, because if you say you definitely get a breakthrough, well, then what if the client don't get a breakthrough? How? Yeah. So in your agreement, you must articulate the reality of coaching for them. Say, hey, coaching is not a quick fix. It will take time. So if you want one session and have a breakthrough with me, I will tell you upfront that after one session, maybe you will not see any change. So I'll give them an example. It's just like going to the gym today. You sweat it out. You work like you work out like crazy, and then you feel so sore. After one session, you go back home, no change. Right? I say it's just like going for gym. You might take several years to slowly see the change happening, but it will be gradual. You will see change happening. Just like coaching as well. It's not instantaneous change, but you see progressive change across a period of time, and that's why I recommend at least a 3 to 6 months engagement. If it's just a 2-session engagement, you may not see the results. I may not be able to help you through. So I let them know upfront what is the reality of engaging a coach. However, if they still choose, hey, I just want to have a sample, I just want to have one session, right? Then up to me to decide whether I want to engage that client or not. So because sometimes some clients are what we call shopping clients. They go around shopping, and then they never quite kind of figure out what exactly they want. Okay, good. Desmond, you had a question.
Yeah, a question on regarding the coaching of minors. Would there be a situation where there's potential some dilemmas, maybe between the minor and the parent or guardian? That's they may have some differences between them, and then it comes out in the conversation, and then there'll be some conflict where these two parties may not see eye to eye, but then you feel obliged to respond in some way. Either it may not be a situation where it's like abusive, that one is quite clear, I guess, under laws, but there may be other issues. You experience this, or what would you recommend?
So if you come issues, let's say for example, it's about coming home late. Okay, curfew and coming home late. So parents say, "Oh, I want you back home by 8 p.m. Right? It's dangerous to be outside." Then the child say, "No, I'm already a teenager. I have my mind. I have my friends. I can do whatever I want." So the child is not wrong. The parents also not wrong. So then how? Right. So this is where when it comes to such disputes, at the early stage of the coaching agreement, we have to let the parents know and the child know. I said there will come time where you have differing worldviews or differing views, and under the law, there's nothing written about it. It's acceptable, right? Either view is okay, and it comes down to the decision by the family as well as the individual. At this point of time, I, as the coach, will not be making a choice for both of you. I will give you the space for both of you to decide ultimately between both of you. And when I find myself in a conflict where both of you come and defer to me about a judgment I should make as a coach, I will refer the judgment back to both of you. Or in a situation where we feel the conflict still persists, I may need to refer this case to a family social worker. Right. So when the dispute escalates and we cannot find a resolution, I'll let them know I'll have to refer this to a social worker to come and mediate in this situation. Just to let everyone know. Would that be okay for all of us? So then you will avoid you being put in a position where you are kind of like being forced to side other party. So I will let them know I will not side any party. Right. I'm not here to be the voice of your parents. I'm not here to be the supporter of anyone. I'm here just to support you in this outcome. So in Singapore, there are social workers who are experienced in working with very, very sensitive, very emotionally charged cases, and they take on this in a voluntary pro bono basis as well. So if you encounter such cases, especially if you are intending to do parenting coaching or youth coaching or children's coaching, you're in that space where it's very, very sensitive to both the family as well as the child. And so you may need additional training according to the different countries. So some countries require to do additional training, all right, to understand the local law of the land. Okay, good. Okay, so that's 2.3. Very, very interesting code there. Okay, now let's go to 2.4. 2.4 is all about how you keep the record. So which is maintain, store, and dispose of any records, including electronic files and communications in a way or in a manner that promotes confidentiality, security, privacy, and complies with applicable laws and agreements. So here you see the word promotes confidentiality. Right? When you see this word promotes confidentiality, very, very well, it's most likely the correct answer. Okay, so let's go a little deeper here. So here, Now we have this idea of this technology-assisted coaching services. So sometimes you have AI. Would you allow AI? So some of us have AI activated in our system, whether it's Apple Intelligence, Gemini, or whichever, Copilot and stuff. So you may be writing notes, and then the AI is reading the notes, creating summaries for you. Invariably, the AI has been trained on the client's matters. What should you do? How should you manage that? Okay, so this is something to think about as well, right? So whether do you activate your AI platform, or how do you secure the information so that AI doesn't read your information? Okay. Now, also ICF professionals manage records and documentation in a manner that works for their practice and confidentiality agreements. So sometimes you may need to keep records, but sometimes you may choose only to store the contract or contact information. All the other records I may delete. Now, there are also country-specific laws that addresses the time requirements for retention records. So this is something important. Not some countries have the laws, so important for you to take note of what are the laws of retention of records or data records. Okay? So important to check with your own countries as well as the law of the land. Okay. Now, ICF is expected that ICF professionals creates a regular and careful handling plan that is timely and thoroughly effective tool to destroy client records and documentation when it reaches a certain stage. Okay. Desmond.
Yeah, just a quick question. I mean, talk about country-specific laws. Let's say if you have your coach that's based here in Singapore, you have a client that's overseas. So which are the applicable laws? Do you take both? If they have differing standards, like, let's say retention of records.
You mean you're coaching someone from a different country?
Yes, for example. I mean, would there be such a situation? And then what kind of applicable laws would
so the relevant laws would be the client's relevant laws as well, and both your laws as well. So
so you have to have both, is it?
Yes, you have to have both, and then you uphold the highest one.
Okay.
Okay, so when you're doing like global coaching, very important to also know their side of law of the land. In case you get sued, so by anyone, so very, very important. Okay, so for example, written documents should be shredded. Deletion of data storage devices should be erased, deleted, destroyed. Now, of course, any data that's on any computer or PC or anywhere will never be fully destroyed. There will be some remnants somewhere, either in space or somewhere. Especially when you have cloud services as well, there'll always be some shreds of information somewhere. So important for you to understand about how to secure your data, right? So for individuals, do refer to your own countries, data storage, privacy, and also there's some free lessons as well. Okay, identify a deletion program appropriate for the type of storage used for records or documentation, or online provider of such services. Okay, so that's fully thoroughly deleted. That's why I always say for prevention of all this is to write in a way that only you understand, nobody else understand. So this is always very important. So sometimes people ask me, wow, Jedi, how come in the class when you draw on the board I cannot read? I say, yeah, so that nobody can copy. So sometimes very important to keep it accordingly. Okay, so here, very, very important here. ICF professionals might also consider addressing their wishes for anything connected with their business in their personal will. Because sometimes while coaching, the client or the ICF professional may be incapacitated. For example, let's say I'm coaching someone, I'm coaching a group of people, and I'm storing all your data in my computer. Something happens to me. I cannot go to my computer anymore. Then have I written all this information down in my will about how all these records should be kept? Okay, so most coaches don't think so far. They don't, but nothing will happen to me, but we never know. Some accident or whatever situation. Right. So important for us to also have something written in our own personal will, so that there's business continuity and also what happens to the client's data when there's a leakage, right? And will you allow say for example, if I'm gone, will my siblings, my parents, or whoever that's access to my computer, will they have access to all the client data? Or what will happen to that? For example, in Apple, if you're using Apple software, it can actually be linked to your time of death or incapacitation. They can actually delete every single thing, right? So if you activate that ahead of time, you can do that as well. So this is something to think about. I think not many people have actually prepared something like this, and invariably when something happens to them, then a lot of their records just gets leaked online. Okay, so clients must be made aware of the possibility of written notes, electronic notes, recordings made during the conversation, and also they should make sure data is secured with appropriate security precautions. Okay, and also constant technological development of these tools and platform requires vigilance, prevent any leakage. So never trust one data. Just make sure that you keep it in a very, very secure platform. Okay, so here ICF also do highlight of certain artificial tools, such as Apple Intelligence, Alexa, Google, Xiaomi, and client consent must be obtained before making audio or video recordings. This also applies to AI. So that's why when you press the record and do the performance evaluation, I say you need to say that again. Yeah. Okay. So, however, ICF professionals is not responsible for how a client chooses to use AI tools. So, for example, if I use, I must let the client know. If the client use, it's up to the client. Okay. So, client can use it to take their own notes, up to them. But if I use, I need to let the client know. Yeah, about how this AI will be using. Okay, because some AI tools, they are training the AI model to do more things. Okay, so they're not like localized, right? So it's important to let the client know as well. Social media also. Okay, so the ICF professional should be aware that information left on social media could be seen by clients affect the coaching process. So that's why today I see a lot of coaching photos, people posting online, photos of their clients, photos of people. And I can see the face very uncomfortable. So just take note, of whether is it okay or not okay for the clients. Yeah. Okay. Any questions here for storage? Okay. So quite straightforward for storage. Yeah. Okay. So let's go the next one. The next one is on fulfilling my ethical and legal obligations to my coaching clients, sponsors, colleagues, and also public at large, directly and through any technology systems I may utilize, such as AI, technology tools, database, coaching platforms, etc. So here, what is important to take note of is any risk of those AI platforms. So increasing with AI and technology platforms, things can be leaked. So if you're using transcription software as well, your audio recording can be leaked. So that's why I always say for the topics that you're doing for your mentoring or coaching evaluation, choose topics that are not sensitive, right? Choose topics that are simple, non-sensitive, or any organizational company related issues, so to minimize any chance of leakage. Yeah. Okay. So ICF does recognize that coaching platforms or executive education companies may have their own rules and ethics regarding confidentiality. However, ICF professionals must understand the rules and ethics of a coaching platform and share information with clients so that they make informed decisions around the coaching process. Okay. So remember, it's always about informed consent. ICF always has this informed consent. Okay. So it's about alignment with the ICF Code of Ethics here as well. Okay. With what? So here, would the use of such coaching platform in any way conflict with ICF Code of Ethics? Or does the coaching platform have its own standards? Or what are the terms of contract for re-enrollment on a coaching platform? And would it in any way interfere with ethical duties of a coach relating to the client? And how does the coaching platform handle data collection? So what's coaching platform? So sometimes some coaches may use websites, some tools, tech tools to onboard clients or apps. And very important for the data, where's the data stored? How is it used? I've met some unethical coaching companies before, right? They say, oh, Jedi, and I'd like to nominate you for some awards, and then blah, blah, blah. Then after that, they got my data. Then after they use the data to kind of sell me things, other products, right? So then they are being unethical in terms of how they're collecting data as well. Okay. So that's standard 2.5. Okay, quite straightforward. Standard 2.6. I am responsible for support personnel's adherence to the relevant standards of Code of Ethics. So this support personnel are people who are supporting you. So sometimes some coaches may have assistants, administrators, some people that may be supporting them to create a connection. So very important for them to also recognize how this is connected for them. Okay, so here, this is to be alert to the responsibility and inform relevant personnel that they may be affected. Okay, so support personnel refer to the people that ICF professional work with, employ or associate. Some coaches may employ, for example, part-time workers or remote workers, right? So or virtual assistants. So these are something that very important to know how to manage them. So for example, they could be coach officers, virtual assistants company that provide services such as speech to text conversions. So these are something that you need to be aware so that they also adhere to the standards as well. Yep. Okay. Now, ICF professionals should be mindful of the ECR process, ethical conduct review process, as it pertains to misconduct of support personnel. So sometimes ICF may conduct this board to ensure that any confidentiality leak will be addressed accordingly. Okay. So this is very straightforward. Now, 2.7. Maintain the privacy of ICF professionals and use of contact information, email, and everything only as authorized by ICF or ICF professionals. So the way you store the numbers, store the data, also very important. So here, ICF says this: privacy of fellow coaches is a fundamental ethical responsibility. So privacy, very, very important to ICF, right? So it says that requires professional safeguard of the contact information of ICF members, such as email address, phone numbers, and other personal data, and only use this information as authorized by either party. So we cannot just add people into a group or just remove people, right? So very important. So here it says a common violation of these standards would be utilizing ICF contact lists to send promotional materials about one's own coaching business without explicit consent. So I've experienced this before, and ICF take a very, very strong stance, and they may also cancel the person's credentials if something like this is done. So there's some unethical coaches that goes around, they get a credential. After that, they go to ICF portal, they extract all the emails from everyone and start selling them, or go on LinkedIn, add everybody and start selling them. Recently, I've seen a lot of LinkedIn messages to me, say, "Oh, Jedi, something. After they trying to sell me something, right? And so I see a lot of these things happening as well. Okay, so here, this is something that you want to refer to ICF privacy policy page. Okay, yeah, so very, very important. Okay, that's standard 2.7. 2.8. Very, very straightforward as well. Comply with copyright laws and recognize and honor the contributions of intellectual property of others by only claiming ownership of my own material. This has been severely violated by many, many coaches. I'll give you an example. I've seen many coaches go online and say, "Oh, I'm using the Grow model." A Grow model is actually copyrighted and trademarked by the originator of the Grow model. Okay, and many organizations, government agencies do not honor the intellectual properties of those individuals, copying it without giving proper acknowledgement of them. A few years ago, when I was running my coaching program as well, someone from one of the students that graduated from my course, copied the entire coaching program and then replicated and then start selling as their own, claiming it to be their own, right? So when I found out that they're doing something like this, I informed ICF, and immediately ICF took action against them, right? Because they literally copy every single thing and then replicate it, right? So this is something very, very important as well. So if you're using some tools, using some models, some frameworks, some things that is not yours, very important to highlight that I'll be referencing this, and I've been given permission by the authorities or by the relevant copyright holders to use these tools for the session. And very important to get that permission, right? So sometimes today, some coaches I've seen, they use, for example, emotional intelligence. So they say, "Oh, Daniel Goleman's emotional intelligence of self-awareness, self-regulation," but they've not gotten permission by Daniel Goleman to use that in the official capacity of a coach. So as a reader, you can consume, but as a user, you have to acknowledge the contribution of the individual. And so it's very important of what you use, how you use it. For example, today I've seen some coaches calling themselves, "I'm a Satir coach. I'm using Satir's principle, Virginia Satir's principle." But upon check, they are not in compliance with the intellectual property of Virginia Satir. So they say, "Oh, come and attend my Satir credentialing," but they are not. But they actually don't have the actual intellectual rights or trademark rights or copyright rights from the originator of Virginia Satir and just sell it off as their own. So very, very important that we don't violate any of this. Same thing for SMART goals, right? So people say, "Oh, SMART goals, everyone knows what SMART goals is," but they did not attribute that. So it's a violation as well. Yeah. So any tools that we use, very important to be very careful not to breach any confidentiality. Okay, especially for ICF as well. Yeah. So be careful of that. Now here, what is important to highlight is ICF professionals to recognize and respect contributions and intellectual properties rights associated with all published or originally created materials. Everything. So, for example, if I say I'm using the ICF core competencies as my foundation, I need to let the clients know that ICF core competencies refers to what is published on ICF website. That is, the ICF allows all ICF professionals to use and to quote. So whenever I'm using the ICF core competencies, I'll be referencing that document, right? So letting them know that this is not my document, but there's ICF documents, right? Or when using work created by others, ICF professionals must clearly acknowledge the original authors and cannot borrow, replicate, and duplicate in such a way with the explicit written permission. So this is very, very important. Today, many coaches are in violation of this. When they go to organizations and claim that they're doing using particular models for coaching. For example, some people say, "Oh, I'm using presence-based coaching," but they're actually using ICF competency without giving acknowledgement, or they're using grow model without giving proper permission, because they know that if they get permission, they have to pay money for that, right? So very, very important to acknowledge the copyright laws. Yeah. Okay. So also ICF professionals conducting scientific research must respect intellectual properties as defined by relevant publication standards. So whether you're doing research, writing, article writing, especially today, a lot of people on social media, they do a lot of article, but they don't attribute where is it from. Also very important. Okay, so similarly, all individual entities collaborating or working with ICF, including speakers, vendors, contractors, service professionals, are expected to adhere to applicable copyright laws and provide proper attribution. Okay, so here are all the ICF attributions, so you can read them accordingly. Okay, so 2.8. Any questions here for these few parts here? Any questions?
Jedi, I just want to ask about the copyright, right? Because nowadays a lot of coaches, they incorporate, some of these models in their so-called coaching program, the training program. So in that sense, also they are violating the copyright.
Sorry, you said that again?
No, I mean, for example, like coaches, right? They are involved in the training program, coaching training program. So they would also mention about those models.
Yes.
So
so they're in absolute violation. Actually, their credentials will be stripped off if they continue to violate. Yeah, it's illegal.
Or even for the facilitation, also considered.
Yes. So, for example, as a coach educator, if you use any of the models, grow model, whichever, without proper attribution and also without official permission, you are also in violation. And then your ACC or PCC or MCC credentialing will also be at stake. That means if you are being reported by ICF, then you will risk losing your credentials as well, and also your accreditation.
But if it's a normal training program?
Same. Because copyright is copyright, intellectual property is intellectual property, which means that regardless whether it's training, you are not allowed to use that without seeking the official permission from the individual. Yep. Okay, very, very important. A lot of people violate this. That's why if you come into my program, everything that I put out there is all my own, so that you prevent anything that's any form of copyright issues. Yeah. Okay, so this is something important, whether you're doing training, coaching, mentoring, that especially for copyright itself. Yeah. Okay. So for some coaches say, "Oh, but I never get charged and nobody sued me before, so it's okay. Everyone is also doing it. The government is also doing it, so can I do it?" Cannot like that. No, even if the government is doing it, doesn't mean that it's okay. Doesn't mean it's correct. Yeah. So it's very important to raise it up to the relevant authorities, where intellectual properties of others, we have to kind of acknowledge that, unless the property has gone into Creative Commons. Okay. So if we know the law of Creative Commons, which means that certain copyright expires for certain cases. For example, Mickey Mouse. Recently, a couple of years back, the copyright has expired, so people can basically take the old black and white good Mickey Mouse and make it themselves, Winnie the Pooh as well, right? And also recently, art pieces like Monet's art pieces, can be copyrighted. I mean, like, there's no more copyright, so you're free to copy it. So do you know that today, if I want to sell a Monet painting, I can do that. It's Creative Commons now, so which means that I can literally photocopy and then sell it, no issue, right? But because it's gone to Creative Commons domain, but for the rest of the things, they are still with a certain, copyright and trademark laws and regulations. So important to keep that in mind. Yeah. Okay. So, and today it's also very important. Some coaches use titles like I'm a some results coach or whatever, and whatever terms you use, just be mindful that whether is that are you given permission to use that, or is it something attributed accordingly, right? So if you don't given the proper permission, we have to avoid using any of those terms. Yeah. Okay, so good question. Anyone else have any questions? Everyone's so serious. Okay, good. No questions on number two. So number two, you will find that section number two or standards number 2.1 all the way to 2.8, you'll find that a lot of questions will come from here, especially on confidentiality and intellectual property rights, right? Who it belongs to, right? For example, the scenario could be a coach uses the grow model and starts promoting a grow model without having official approval from the originator. What should you do? So sometimes you may come across this situation. What should you do? Right. So all this very, very, very important. Yeah, as a coach to uphold the highest standards of ethics. Okay, good. Any questions from anybody? No. Good. So what we'll do, since we're only left with like about 10 minutes, we'll go through a few questions and then the rest will continue the next time. Okay. So this will be a fast round, very, 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 very fun round. Okay. So this part here, very challenging, but the questions will be more interesting than part one. Okay. And I like this part here. Okay. Are you all ready? Okay. So this is section number 2 on questions, to test your understanding. Now, question number 1. Which of the following most accurately reflects the ethical requirement under Standard 2.1 on confidentiality? Okay. A. A coach must keep sessions content private unless explicitly waived by the client. Or B. A coach can share insights with peers if they remove names. Or C. A coach may disclose clients' concerns if they help client indirectly. Or D. A coach may keep notes on clients as long as they are not in public place. A, B, C, or D. Okay, so this should be quite easy. A is the answer, yeah? A. Okay, so keep sessions content private unless given approval. Number 2, a coach uses ChatGPT to summarize the transcript but doesn't inform the client. Which standard is most at risk? Okay, so let's test your memory on the standards. 2.3, 2.4, 2.5, 2.7. Okay, I'll help everybody. You see everybody's so stressed. Okay, let's go here. Which one? Use ChatGPT to summarize.
Yeah, Jedi, I wanted to ask, exam really got this type of question. Give you 2.3, 2.4, 2.5, then the answer is like that one.
I don't know.
Like that die, man.
No, they will not be so bad. I'm more bad. Right.
Okay.
They'll give you the words. Yeah.
Okay.
Yeah, but they will not tell you
Scare me.
but they will give you the words itself. They extract the words.
Okay.
Yeah, but now we're just trying to test you. Okay. So if you use ChatGPT or any AI platform to do summary, what of these standards is it in violation? Okay. And this is testing boundary. Yeah, 2.4. Okay, so most of us say 2.4. Okay, so maintain, store, dispose of records electronically. Okay, so let's go and take a look at that. Okay, so actually it's 2.5. Right? So let's go to 2.5. Okay, so because you didn't inform which standard is most at risk. So let's go to 2.5 here. Fulfill my ethical legal obligation to coaching clients through any technology systems I may be utilizing, such as technology assisted coaching tools. Okay, so I need to be able, because you're not storing them, but you're using them, that I may utilize in the session. So it's more of 2.5. Okay. Okay. So Question 3. A coach anonymizes a client's story and shares it in a podcast. The client later says they recognize themselves and felt exposed. What ethical standard does this most directly implicate? Okay, this is how we talked about this earlier. Let me go back to this part here. Okay. So I share their details on a podcast. It can be podcast, it can be social media, LinkedIn, anywhere, without saying their name, but they feel exposed. Okay. Anyone? Oh, everyone's still thinking. No idea. Okay, we covered this a little bit earlier just now. Something about this exchange or something like that. Okay, something along the lines of exchange. Okay, and let's see. Answer is 2.1, right? So even anonymized stories can violate standard 2.1 if the client can reasonably identify themselves or if informed consent wasn't even obtained. Okay, so let's go back to 2.1 again and see what 2.1 says, right? So 2.1 is maintain strictest level of confidentiality for all parties. So that they will not be identified. So this is what we talked about earlier, right? A coach shares success story. So success could be podcast, can be LinkedIn, can be anywhere, social media, anywhere. Yeah. Or even books. Yeah. So anywhere, don't no names mentioned. So very, very important that details are specific enough that the client should not be identified. Okay. Good. Easy, right? Okay. Question number 4. Before coaching engagement, which one of the following best aligns with standard 2.2? Asking the client to sign a general consent form, clearly co-creating with the client what is shared, when, and with whom, telling the client everything here stays between us, mentoring confidentiality in the welcome email. Okay, mentioning confidentiality. So let's go to 2.2. It's about have a clear agreement of what information exchange and how. So exchange and how, right? What information is exchanged and how. Okay, so what do you think it is? Okay, so we're saying B, B, B. Okay, so answer is B. Okay, so it's about what information exchange, when, and how. Okay, so co-creating that. Okay. Question number 5. A coach agrees to provide coaching session summaries to the sponsor without discussing this with the client. Which standard is being violated? Okay, so a coach agrees to provide coaching session summary to the sponsor. Let's go to the different standards. Which one of the standards is being violated? Okay, let's see everybody's answer. 2.2, 2.2. Okay. Let's take a look. Answer is 2.2. Okay, so very, very good. How do you find the question so far? Okay, don't worry. We have about 50 questions for this one. So so we're going to continue this in our next session where we're going to test you a little bit more. This part here requires some time to kind of digest. So think through some of the ethical dilemma that you may be facing. And in our next session, we're going to go through a little bit more and we're going to dive in straight to some questions. Okay, so familiarize yourself with 2.1 or the 2.8, right? And 2 and 3 are very important. Okay, so in terms of all the standards within the ICF, especially part 4, section number 2 and section number 3, standards 2.1, 2.8, section number 3 as well, very, very important. Okay, a lot will come up from it. Okay, how do you guys find it? Easy? Challenging? Not easy? Okay, but congratulations for tuning in. I know it's not easy. You'll find that we are raising the levels of our ethical understanding, and this will apply also for the PCC level learners, because PCC, they're also going to test on ethics, but the scenarios are going to be more challenging.